could not give Mr. Messerman the justice and accolades that these people who are going to introduce him can. So I brought up his former law partners, Mr. Nicky Schwartz and Judge Harry Hanna, who were part of the law firm, and those two, and Mr. Gold was going to be here, but I think something, there was a conflict, so Nicky and Mr. Hanna are going to do the pleasures of introducing our guest speakers.
They're going to take all my time.
They're going to take up all his time.
Yes, yes.
Come on up, Nicky. Stand up here, guys. Come on.
Okay, all right.
You're in.
Okay. The law firm of Gold, Rotatory, Messerman, and Hanna opened its doors in the Investment Plaza in February of 1971. Jerry Messerman left us in 1980 to practice with his wife. It is not that he loved us the less, but he loved Gail the more, as it should be. We all went on to successful careers and to high visibility triumphs, but we never had more fun, and we never had more professional satisfaction than we had during our time together in the 70s. It was a magical time. And so I think it's fair to paraphrase from Lerner and Lowe, don't let it be forgotten that once there was a spot for one brief shining moment, Gold, Rotatory, Messerman, and now, as of today, Brendan Sheehan will have given four of us the opportunity to be heard in this forum, and a good argument could be made for the proposition that he saved the best for last.
I agree.
Jerry Messerman is a true son of Cleveland, a proud graduate of John Adams High School, Western Reserve University, Western Reserve Law School. And while at Western Reserve Law School, he had a professor named Larry Herman, who touted him onto and recommended and assisted him in becoming a Prettyman Fellow, an intensive trial practice program at Georgetown University. While there, as part of the Prettyman Fellowship and afterward, he served as a public defender and as an assistant United States attorney. He then was recruited to become a law professor at The Ohio State University by Larry Herman, who by that time had left Western Reserve and was on the faculty at Ohio State in time to be my criminal law professor my first year in law school. And Jerry taught at Ohio State for 3.5 years and then came to Cleveland in 1968 to engage in private practice. And a combined result of his brilliance and his outstanding training, he became the leading trial lawyer in the community. And that's a pretty broad statement to make, but I offer three of hundreds of pieces of evidence that could be offered in support of that proposition. One is that eminent sage Jerry Milano, who used to say whenever there was an argument about who was the best trial lawyer in Cleveland, that the argument was only about who was number two, because everybody agreed that Messerman was number one.
I agree.
Further evidence of that proposition was that every time one of the big firms or big companies or big governments got its breast caught in a wringer, it brought in Jerry Messerman to help them deal with it. It made him kind of crazy to deal with some of the big firm lawyers, and what made him craziest was the statement, "It could be argued that." And why did that make him nuts? Because although it could be argued that, it probably shouldn't, because it wasn't credible. And so in addition to his brilliance and his training, what made him a great trial lawyer was that he understood better than anybody the three fundamental principles of litigation. credibility, credibility, credibility. And the final piece of evidence, certainly my own judgment, manifested by when I was subpoenaed to appear before the Scioto County grand jury after the Lucasville prison riot. The prosecutor told me that he wanted me to testify about my conversations with the 3 inmate leaders, my clients. I was not going to utter a word of it and was prepared to go to jail before uttering a word of it. But there was no question who I was going to get for my lawyer, and it was Gerald Messerman. So it is my great pleasure to introduce my great and good friend, Gerald Messerman.
I have to tell you, Nikki, being asked to appear with you at that event at Lucasville was a great honor, one of the greater honors I've received, because there you were the hero, you were the person who brought that thing to a conclusion. You did something that no one else could make happen. And at the same time, I was representing the governor and the wardens of Lucasville, so it was nice to be with you. I haven't spoken for a long time, but as I look around, I'm tempted to change what it is that I was going to talk about, and I'm going to talk about a few cases just that I think capture what I saw in the practice of law from a relatively early time. And I see one person here, Jerry Pokar. And Mr. Pokar is a writer, amongst other things, and he brought me to a client that I had not seen for many years. A few years ago, the client was in a nursing home, and he had told Mr. Pokar that he should get in touch with me because I was the only one who could get him out of a nursing home. I almost got into it myself. But apart from that, seeing this man, whose name was Thomas Lee Bailey, was a reminder of so many different things that happened to me as a lawyer, because Thomas Lee Bailey emerged in the following circumstances. When I was teaching and running a legal clinic at Ohio State, one of the things that we did is to set up a program which we would take information from people from inmates who wrote from the Ohio Penitentiary, and we would take some cases. And one of the early complaints that I had heard about the Ohio Penitentiary I received from the appellate court judge who subsequently was on the Supreme Court, who was a Republican, but he had a wife who was a Democrat, so we got along well. And he told me that he had heard that there was someone in the Ohio Penitentiary who had been in the hole for a period of over 90 days. And being in the hole meant that you were held in solitary confinement, no bed, you were on the floor. You would have regular food every 3rd day. The intervening days you would have water, keep you hungry. It was a brutal kind of thing, and limitation was supposed to be 10 days. No one would be in there for more than 10 days. This man, it turned out, he had heard, had been there for 90 days. I could not find out who it was. When the Ohio riots occurred at the Ohio Penitentiary in Columbus, there were 2 riots separated by approximately 2 years. 2 months. And since I've been heavily involved with the penitentiary and with inmates, I offered to take one of the 57, I believe, cases that was filed against those who participated in the riot. And the man I represented, I was appointed to represent, I was living in Cleveland at the time, was Thomas Lee Bailey. Well, it turned out that Thomas Lee Bailey was a man who had been in the hole for 90 days. And that became a very important part of Thomas Lee Bailey's defense in the case. It also turned out that Thomas Lee Bailey was a leader of at least one of the 2 riots, and they had him on television. And we had, as a prospective juror, at the trial of this case, a person who was a reporter at the riots and who saw the riots firsthand. I made a decision not to challenge that juror and kept him on the jury. To make a long story short, we went to trial, and Thomas Lee Bailey had been in jail at the time that I first saw him for approximately 6 years, and he had gone there for endorsing a check that bounced. That's not a very major offense, but it carried 1 to 20 years or something like that. And he stayed there for a long time because first, he was in a fight when he resisted a homosexual attack. He was young, he was attractive, and he was a good fighter. And secondly, he didn't resist an attack. Oh, and by the way, he was then denied parole on the basis of the fact that he was involved in a fight, and he then didn't resist an attack, and he was given another refusal of parole because he participated in the homosexual act. And this kept going, down the road for some period of time. And then he refused to be placed in the general population because he was just so he was a real big problem, and he stayed there. We went to trial on that case. The trial, the defense was not guilty by reason of insanity as to one of the counts and not guilty on the other. The reason for asserting the defense of insanity is we felt we had to get him out of the prison immediately, or he was going to be killed if he got acquitted of both, and remained in the prison population. And he was acquitted, and acquitted by reason of insanity, and sent to Lima immediately, not back to the penitentiary. So that case embodied everything that I saw going on in the criminal justice system. Someone spending that time in that environment for that period of time for that kind of an offense. And it was an inspiration to try harder. Criminal cases were not easy to handle, but as Nikki said, I had a terrific advantage at the very beginning because I got into this fellowship program. One of the things that happened is that I tried a case. My first case was a misdemeanor. A man had stolen some food from a church. We went to trial on the case, and he was acquitted. When he found out that he was acquitted, I told him he was acquitted. He said, "What are you talking about?" He said, "Well, you're found not guilty. You're free to go." He said, "Where am I going to go?" He said, "Well, you can go home. You can go wherever." He said, "It's almost Thanksgiving." He said, "I always spend Thanksgiving in prison." "Why did you do that to me?" And he was very angry with me. And I was subsequently told that he threw a brick at a jail window and got himself arrested again. And that was my first victory. I then went before a judge whose name some of you may recall, in a case where I was there only to sit second chair, because that's what we did in the Burning program. All felonies then were tried in the United States District Court for the District of Columbia. So you were trying felonies in a very high court. And the idea was that we would sit second chair for one of the public defenders, and we would learn how to try cases. But the public defender who was working on this case, and it was a murder case, had left the defender's office and gotten a real job. And so I went in before Judge Alexander Holtzoff for the purpose of getting a continuance. It was my first appearance officially as a lawyer in the United States Court for the District of Columbia. Holtzoff was the man who wrote with Barron and Holtzoff, the learned treatise, a long time before any of you were practicing law, I suspect. But it's like Wright and Miller. You subsequently had Wright and Miller, and I don't know what you had after that, but he was a great, renowned scholar who had been a very powerful member of the Justice Department for about 20 years, and he was a terrible man to deal with. He was a tyrant, particularly with young lawyers. And the truth of that is attested to by a man who was the head of the Appellate Division of the U.S. Attorney's Office in the District of Columbia, who was my boss sometime later. But I'll get to him in a moment. But anyhow, I asked for a postponement. This is my first appearance in the court, and that's all I'm asking for is a postponement so they can get a real lawyer. And the motion was, he said, how long have you been on this case? I said, about 4 weeks. He said, well, don't you know anything about this case? I said, yeah, I know a little bit. I've not tried cases of this magnitude before. He said, you're licensed to practice law, you're appointed in this case, you're on this case, you'll try this case. And I did. That was a difficult choice by the people in the Prettyman program at Georgetown University, but I tried the case. And it was a very simple case. The man was charged with beating the woman that he was living with to death. The evidence against him was the mother of the woman who was dead, and she was the owner of the apartment that they were in, and she saw him beating this woman, and she was a 25-year government employee, and she didn't want him living there anyhow, and she was a very hostile witness, but she saw him being beaten, and she had died of subdural hematoma, and there were bruises all over her body, etc. That didn't sound like a very good case. I found out with an investigator that what had happened in this case is this woman she was an alcoholic. The man she was living there with was also an alcoholic, and she fell. She was seen to fall a number of times shortly before this event occurred, and she played cards regularly, and in the days immediately preceding this, she was having trouble holding the cards, and the cards were dropping, and so on and so forth. And it looked to me, or sounded to me, like there might be some existence of pre-existing hematoma, and I had to get an expert on the question, and I contacted someone at NIH I knew, and he introduced me to Paul McHugh. Does that ring a bell with anyone? Paul McHugh is probably the leading opponent of transgender operations. He was for years, he was the head man at the major hospital, Johns Hopkins. He was a neurosurgeon, and he was 30 years old about then. He's now 87. And he agreed to look at this case. And we went to the coroner's office, examined everything, and he said, this woman had pre-existing hematoma. He said, this is not a fresh hematoma. This would not have been caused by a recent beating. And he became very worked up about it. He had only 4 or 5 children then. He subsequently had 4 more, I think, but he got very, very worked up, and he was overstating the position a little bit, and then I had to tell him that, you know, even if she had a pre-existing hematoma, if he cut her life by 5 minutes, it could be murder. So we've got to be very, very careful with this situation, and he's getting much too optimistic about it. We're trying this case in front of Alexander Holtzoff, okay? And he's a very tough guy, and he's very anxious to beat up on me, and he did. And the way he conducts himself was very effectively described by this man that I was telling you about, the head of the Appellate division, when he brought me into another murder case. And this was a murder case that had been tried by Judge Holtzoff, and this was his 4th or 5th trial on the same case, 3 of them before Judge Holtzoff. And the case had been reversed several times before, and he had probably run out of times to be tried again. But the man who did this, Frank Nebeker, described Holtzoff as follows. He assigned me to handle this case on appeal. He says, for anyone who knows Judge Holtzhoff knows that he was at the time a very demanding and a very strict but brilliant U.S. District Judge. I can recall coming into his chambers with this proposal, and though he was a man of very short stature, when he would begin to be upset, he would bounce up and down a little bit in the chair, and he indeed began to bounce up and down in the chair with this proposal. He used to do that on the bench as well when he was upset with counsel. I say he was a very demanding man. You did not cross your legs at counsel table. You did not put a briefcase on counsel table. You kept it on the floor. When you addressed the judge, you addressed him from the lectern, and you did not communicate with opposing counsel. I'll tell you, it was almost a capital offense if you violated any one of those rules. So I'm trying this case, the first murder case, let alone, in front of this judge, and he's beating up on me and saying very nasty things to me in the presence of the jury. And I have a pretty good defense in this case. And this man is really dumping all over me. And the Georgetown had decided to have several people watching this trial because I was way ahead of the game by being involved in this kind of trial. So there were plenty of people present. So at one point, after he had jumped all over me, I asked to approach the bench. He said, no, I asked for a bystander's bill of exceptions. Well, I don't know. How many of you have heard of the bystander's bill of exceptions? Bystander's bill of exceptions is when you have something occurring in the courtroom that you can't, it's not on the transcript, you can see it. And you can have people, the bystanders, people who are in the courtroom, give testimony as to what it was that they were seeing. And that's what we asked for. And he asked me, where did I learn about a bystander's bill of exceptions? And I said, Your Honor, I must have learned about it from your treatise. Where else would I get it? And he was absolutely delighted. And that little event, which is the whole story, frankly, of the practice of law, in my opinion, that little event turned the whole case around. We completed the trial, cross-examined the forensic pathologist, got a judgment of acquittal, didn't even go to the jury, and I was death qualified from that point on. I could try any kind of case. And he requested that I try another case before him. And the case was a case that apparently had caused a lot of problems to other lawyers because the defendant was a gay man who had been working at a restaurant on the hill, who had daily, he would take the cash returns and take them to the bank. And one day, he took the cash that had been collected for the day, and he disappeared. And the cash disappeared. And so he was charged with theft, but not until they found him. They found him in New York City, where he had been, he won the event that he attended annually, which was the Female Impersonators Ball, and he was queen of the Female Impersonators Ball. He was very gay. He was swish gay. That was a much more difficult thing to handle back in those days. And he insisted, when they arrested him in this New York place, he was in a very nice apartment, and had very nice clothes, and had money, etc. And he said that he was staying in this apartment because his good friend had died, and his good friend's uncle had told him that he could stay there. And his good friend's uncle, he didn't know his last name, but he owned a Chinese cookie factory. Cookie factory. Well, the story sounded pretty ridiculous, but based upon what I'd seen already, it was important to check it out. And we checked it out and found the owner of the Chinese cookie factory. And he confirmed what was said about where the man was staying and a lot of the clothes that he had and some of the money that he had. Now, if you go through things like that in your life or in your practice, you begin to think, you can't always come to conclusions. You have to be very careful to keep an open mind. And in this case, the owner of the Chinese cookie factory came in to testify. The employers of this man said he was an excellent employee. They trusted him, etc. He was acquitted. So I had 2 acquittals, and was up for a third. And the third one I tried, I was sure the man was innocent because he looked at me and he told me he was innocent, and he looked to me so innocent. I knew he was innocent because I'm a good judge of character, so this man was obviously innocent. This time, the judge was Luther Youngdahl. Anyone familiar with the name Luther Youngdahl? He was governor of, I think, Minnesota. He was a terrific judge. I'm trying the case in front of him, and the most damaging evidence they have is fingerprints on the inside of a glass piggy bank that was broken during the break-in. Well, that would seem to be pretty good evidence, right? His fingerprints on the inside of the piggy bank that was broken in the burglary. But he said he wasn't guilty, and I believed him. And we got a fingerprint expert. They're all from the FBI, and this one, he said he looked at it and he said that it was his fingerprints. So he confirms what the government is saying in the case, but he still looks at me and his big eyes, and I know when someone's telling the truth or when they're not telling the truth. And we go to trial, we have a wonderful jury, and they're out for approximately 45 minutes and they can convict. This is my first loss. They convicted, just like that. I went back to the room where you would meet with prisoners in that courthouse, and he said, "Listen, I really appreciate what you've tried to do for me. I apologize, but I did it." He confessed. Well, I'm so glad you finally told me. I think there was some error committed during this trial. I think we might be able to get it vacated, and I think we could then get you youth correction, etc., etc., etc. He said, "Well, thank you very much. I know how hard you worked on this case." I filed a motion for a new trial. It's granted. I go back to the room to meet with him and tell him that he's going to get a new trial and we can now apply for youth correction, etc., etc. He said, "I'm not going to do that. What are you talking about?" I said, "Why not?" I didn't commit this. I didn't do this. He looks me straight in the eyes and says, "I didn't do this." Well, cases, 3 cases in a row give rise to a lot of information about how you feel with those things. Fortunately, I stopped doing that, and I went into the prosecutor's office, that is into the U.S. Attorney's office, and in that place, I handled 26 appeals and learned a lot about the appellate process and about the law, for that matter. But one of them that I handled was the case that I just mentioned, Willie Lee Stewart. Willie Lee Stewart murdered a grocer in front of his wife and daughter. He went to trial the first time, was convicted, sentenced to death. There was an automatic death penalty in murder cases then. The conviction was reversed by the D.C. Circuit Court of Appeals. He went to trial the second time, same result, reversed by the Circuit Court of Appeals. He went to trial the third time, Circuit Court of Appeals affirms, reversed by the Supreme Court. The office then goes to Congress and says, "We can't deal with this automatic death penalty. You've got to get rid of it. We've got to have this changed because we're not going to get a death penalty upheld here." And Congress changes it. It's up to the jury to decide whether it's life or death. And they have the fourth trial, and there's a hung jury. They can't agree upon the sentence. And then there is a fifth trial. They don't. Again, the government does not ask for the death penalty, and he's convicted and sentenced to death. It's going to go to the circuit court, and the man who wrote the brief on the case, a fellow by the name of Robert Martin, the lawyers who used to write the briefs in the cases who were not paid in indigent cases, the briefs were incredible. They were just remarkably fine. And this one was extraordinary, and it had one big issue in it, and and that is there was a claim of the child with the right to speedy trial. I've tried it now, this is a number of times, and you can't do it anymore. So it was decided to try and get a plea. And the process of doing that was quite remarkable and involved at the highest level. The United States Attorney at that time was David Atchison, the son of Dean Atchison. The second in command was Charles Duncan, the son of Todd Duncan, the original Porgy and Bess. They were both very smooth operators, and it was very interesting to see what they did. Apart from these criminal cases, and I'm only going back to Washington days and one Columbus days, when I moved on, and particularly when I was at the Gold Road Authority firm, the interesting thing about being with the Gold Road Authority firm is that I didn't get any cases, or very few. Gold and Rotatory and Hannah and yeah, they were big names. Nikki and I were somewhat different situations. But when I would get a case, like we got a case, and I say we, I'm not sure whether it came to me or to Jerry Gold, when Joe Esterhaus, remember Joe Esterhaus? When he was placed as a defendant in an arbitration proceeding because he had written an article in the Evergreen Review, and it is this article that exposed the My Lai massacre. The My Lai massacre came into existence. No one knew about it, but for a GI, Cleveland GI, who had taken the photographs that subsequently became so famous and were published in newspapers all over the world, we might never have known about the My Lai massacre. Well, Joe Esterhaus learned about these photographs and was very interested in the story and thought the photographs could be sold. And at the time he was working for the Cleveland Plain Dealer, and he and the photographer kind of set up an auction for the sale of those photographs, not knowing that, well, they kind of showcased some of the photographs in the Cleveland Plain Dealer. That's the first place they were shown, was the Cleveland Plain Dealer. And they didn't realize that they would be pirated all over the world, and that the value of their photographs would change substantially as a result of what they had done. And this article by Joe Esterhaus is probably a confession, the selling of the My Lai massacre. If you haven't read it, it's a 15,000 word article. It's very well written, and it tells some bad stories about the Cleveland Plain Dealer and about reporters generally. And we were hired by the Guild to represent him because he was fired by the Plain Dealer. He didn't really care about being fired because he was already under contract to Rolling Stone, and that was his next move. So that's not what it was about. It was about the article, which was very critical of him, and I mean of the Plain Dealer, and he thought he should not be fired for that article. So we had a long hearing, and Jerry Gold started off with me in it, and then he got bored. That was not unusual. Jerry liked fast, not easy, but fast. And there was a lot of stuff that was boring in this trial. And anyhow, we tried the case, and it was tried to an arbitrator, and the arbitrator ultimately concluded that Mr. Esterhaus was a great writer. The arbitrator immediately grasps the fact that Joe Esterhaus was a great reporter, equipped with all the skills requisite to write so the public wants to read it. His quality is adequately established by manifold congratulatory letters and notes sent by publisher Tom Vale, etc. He says, frankly, if I were the publisher, I would want to hire Joe Esterhaus with his several faults. He was one of the special breed of reporters, et cetera, et cetera, et cetera, et cetera. Very nice things about him, but he upheld the arbitrator's award. What we thought was going to happen in this case, we had a huge, large auditorium. We thought a lot of people were going to come and watch this case. From the standpoint of the guild, this was important because they were looking at criticism from within. The problem with newspapers is, you know, they do a lot of things and it's okay if you know about them. Now we hear about them all the time. I mean, we watch television and that's all we hear is about the newspapers. But then we didn't hear anything about the newspapers, and we particularly didn't hear from insiders. A couple of the newspapers, the Washington Post, etc., had ombudsmen who were doing this kind of thing. But it generally wasn't being done. It was a very thoughtful article, and it was a very game, legitimate aim that the Guild had, but it wasn't accomplished because after the first day, I hope it wasn't my performance, but practically no one was there. And there was virtually no coverage of this trial. Joe went on to fame. He became, I'm sure you know, a very well, highly recognized screenwriter whose films, 16 movies, brought in over $1 billion. But then he had some other problems when his father, who was a lawyer and a writer, and a newspaper publisher himself, Catholic daily, Hungarian daily, was investigated by the Office of Special Investigation for being a Nazi war criminal. This was very, very bad situation, and I can disclose the situation because Joe has disclosed the situation, but if you remember the movie, what's the name of it?
Music Box.
Say that again?
Music Box.
Yeah, Music Box with Jessica Lange. Jessica Lange played a lawyer who represented her father. This was like the same story. So it was something very, very difficult for Joe to deal with because he was having big problems with some of the leading people. The cases that I dealt with at Ohio State, and I'm going to deal only with one of them because I see that my time is almost up, where what we were doing is trying to get students to understand the process of the criminal law and of the criminal justice system. And it was a very intense experience for me, and I hope for them. But the very first case that I tried was one thing that I'm going to mention very briefly. But one of the things I have to say about what was going on in my life as a lawyer, we talk about handling cases and getting cases, etc. And one of the big problems that you have, particularly in a criminal practice, is how do you get cases? And how do you get, referrals from large firms, and et cetera. And one of the things that became apparent to me, I had several really successful results in a row in cases that had some publicity. But one of the things that happened with me as a result of my participation in the plain dealer prosecution of Joe Esterhaus is that I got no publicity whatsoever. I mean, my name wouldn't appear. It didn't matter what kind of cases I handled. My name would not appear. Something might appear about the cases, but my name would not appear. And all the cases that would come into primarily jury and trial. And Harry had his own source too, and Nikki did some stuff. But Nikki and I were not in the same category as far as production of business was concerned in that 10-year period. Some cases came in, And then I started handling civil cases. And handling civil cases was such a relief. I mean, those things are such a bargain, especially when you have complicated antitrust cases before Judge Nugent over there. They're easy to handle. But the civil cases are so much easier. You get discovery, you have all these wonderful things happen to you, and the judges tend to be much nicer, in my experience, when you're handling a civil case than when you're handling, it's a totally different world. And so I started handling construction cases. And one of the cases I handled was a case that I wanted Nicky to handle, but he wouldn't do it. And I ended up representing two lawyers who were trying to build a Section 8 housing project in Defiance, Ohio. And the people in Defiance, Ohio didn't want the Section 8 housing project because that would bring in blacks and Latinos. And they did everything they could to prevent it from, and it didn't take too much to prevent it from being built. They denied them egress to their property that they owned, and ingress, and they denied them a water hookup. And that would, kind of take care of it. And so they wanted to sue, and they had to have a result within 6 months or less, and so we went to federal court, federal civil rights action, and went before a good judge, and he decided it properly, and we had a decision within 4 or 5 months, and then we went and had a trial on the money damages, or they paid, I can't remember for sure which, but as a result of that case, and this is something that, I don't see too many very young lawyers here, but a single case can change what happens to a practice. And what happened in that case is that Gail and I ended up with the bond court case. The bond court case is the case where the bond court was falling down. And the interesting thing about that case for me personally was that I had tried in the 15-month period where I was with the Berkman, Gordon, and Cancelbaum firm, I had tried what do you call it, when you violate a copyright, or not a copyright. Someone was, Roman Hamas, the manufacturer of acrylic latex, was suing my client because he was using their product. Actually, we were suing them, we were suing them because he was using their product to mix with paint. I was representing a paint chemist, he was with a paint company, and they were using a mixture of paint and acrylic latex to put down in places where, where you had food and other things that would cause the concrete to split and create unhealthy situations. And it doesn't sound very exciting, but it really was. And we tried that case before Judge Green and lost it. But we were in the Superior building when we were trying that case, and they were starting to build the red brick building directly across the street. Everyone know that building, the bank building?
Central National.
Okay, whatever building it was. My client saw that they were putting that building up, and they were using a product called Cerabond. And Cerabond is a polyvinylidene chloride latex made by Dow. It's the same thing they use to make saran wrap. Okay, so they had Cerabond, and they're using it to lay brick mortar in place. And he said to me, my client said to me, they can't do that. That building will collapse. Why will it collapse? He said, because this is what that's made of, and the chlorides will release, and they're being held to the building. You've got steel reinforcing rods, and they're going to expand, corrode, and break the bricks, and the building's going to collapse. Well, as you may recall, that building had to be remade 10 years later, and that was a very expensive project. And the same thing happened with the Bond Court building. The difference was that the Bond Court building was 22 stories high and had prefabricated panels that weighed between 2 and 4 tons on the side, and that were attached with steel, whatever you call them. And they were concerned, you know where it's located, that one of these things was going to drop, and it was a real hazard. And it was owned by John Carney's uncle, and I handled that case. So my practice changed rather significantly, and it was much easier to get civil cases than to get criminal cases, and frankly, in many ways, much easier to try civil cases than to try criminal cases, and the stakes weren't always as bad. Going back to this case, I saw this man after this man being Thomas Bailey. I saw this man after Jerry Podar was trying to write a story about him and wrote a story about him. This is the story. This is the book about him. And what he accomplished after getting out of that prison was unbelievable. He became, first he got a degree from Tri-C, then he got a bachelor's degree from Cleveland State, then he got a master's degree. He was choir director in 3 churches. He lived an extraordinary life, and it was something that made all of this stuff seem very worthwhile. So I think I'm probably about up. Anyone want to ask? By the way, we also represented a lot of doctors and a few lawyers. As a matter of fact.
And a judge. Do you have any questions for?
And a few judges.
Yeah, great. Mr. Messerman, comments, questions? I have some questions.
I'd be happy to talk. I don't know if you expect me to end at this point, but
No, it's up to you.
well, here, let me just.
Your question in the
I
back?
have a question.
Yeah, go ahead.
Go ahead, Ed.
Gary, I once heard that F. Lee Bailey said if he was ever in trouble, he would hire Jerry Messerman from Cleveland. My question is that true, and did you have a relationship with F. Lee Bailey?
Well, he's had a lot of trouble and he never hired me. So I think that that's probably not true.
Jerry, he said it on Johnny Carson. He said the best criminal lawyer is a guy out of the the Midwest. His name is Jerry Messerman. He said Johnny Carson, I saw it person. Heard it.
Well, I'll tell you, we represented, I say we, Gail and I represented a lot of lawyers. And we went to trial with a lot of lawyers. And we had a pretty good record, but I can tell you, we did occasionally lose them. And when we did, it was our fault. That is one of the ways that you have to deal with, I mean, you have to deal with lawyers. Sometimes, by the way, it's true. When I say we represented a lot of lawyers, I really wouldn't like to tell you about this. By the way, the case that Nicky handled, where he got the client out, I mean, when I say he got the client out, he got the Sixth Circuit to affirm the judgment in the Woodard's case, where the man was charged and convicted of raping and murdering an 85-year-old woman. I tried the case before a federal judge in Columbus, before Judge Canary. The judge found that the trial was, constitutional rights had been denied, and very shortly after that happened, I was fired by Mr. Berkman, who was the head man at the firm. And so this was a Berkman case, and Berkman had been working on it for 2 or 3 years, trying to get the conviction set aside. But he really wanted to have the standard for insanity adopted by the United States Supreme Court as required. But anyhow, after Judge Canary granted habeas in this case. Nicky handled the appeal, and he got it affirmed in the Sixth Circuit. That was a miracle to get that case affirmed in the Sixth Circuit. When I say that was a miracle to get it affirmed in the Sixth Circuit, I say it because one of the most disturbing cases that I tried in my life involved a man whose name was Charles Victor Johnson. All of my clients, Nicky will tell you, had three names. That's the only way I could remember them, is that they would have three names. But Charles Victor Johnson was tried for 2 rapes that occurred in Ravenna, Ohio. He had no prior record. He had a job. He was married. He taught Sunday school. He had a 2nd grade education. He worked. He had an alibi for the 2 dates involved, although he wasn't given much information about it, that were very solid alibis. And you know, an alibi is the most difficult defense to present next to insanity or entrapment. There's nothing more difficult than alibi. Because most of the time, when you're doing alibi, you're with someone who knows you, and that they know you and they like you, or they're relatives or whatever, so they've got an interest in the outcome. Or there's someone who doesn't know you and they don't remember very much about what was going on. And everything in the instruction about alibi, everything, it's just a terrible thing. Jerry Gold and I tried a case once. It was a murder case. And at the conclusion of the state's case, we had an absolute winner. But we also had 7 alibi witnesses. And we decided we would leave it to the defendant to determine. You know, they were reliable people, etc. But if you're going to have 7 alibi witnesses, you're going to have 7 different stories. And we presented the alibi witnesses, and he was convicted of murder. And this was a case where, in my opinion, and in juries, there's no question at the conclusion of the state's case, we had a winner. Going back to Appellate Bailey's statement about lawyers, we represented Bob Hausen in a case where we had to go against the entire Catholic Church and 8 priest witnesses and so on and so forth. And he was charged with extortion. And he was charged with extortion because he had gone to the bishop and to complain about his client's complaint. His clients were the president of the congregation, and the choir director. And the choir director had been having sexual relations with what they preached. And they wanted that to stop, and they wanted the church to take some action, and the church didn't take any action, and they tried to get something to happen for some period of time, over a year. And then the president of the congregation, who was also a lawyer, got a lawyer and got Bob Hausen. Bob Hausen was pretty well known, and he was a very aggressive prosecutor, but he was no longer in the prosecutor's office when he was charged with extortion. And we went to trial on an extortion charge in front of a judge, and it was when the state had finished presenting its case, I saw the county prosecutor walk into the courtroom the next day when the judge announced that he was going to rule upon the Rule 29 motion. And the judge was there the prosecutor was there to hear what the judge had to say, and he granted the Rule 29 motion, much to his credit, I think. But we represented a number of lawyers. We represented a very well-known lawyer from Lorain County, biggest firm in the county, in trial for 3 months in that case, along with another man who had rather substantial reputation, representing the head of the company that was involved in the case, and I was representing the lawyer who was involved in the case, and the other man was Gail.
Brendan Sullivan.
From Washington, Brendan Sullivan. That's right, thank you. Brendan Sullivan's a great lawyer. And, you know, maybe the best criminal lawyer in the country, if the Bailey is wrong about me. I mean, he's really a great lawyer. And we tried hell out of that case. It was a very complicated case. We had a jury of 18. We started in early September. We finished in early December. The jury was out for 7 or 8 days. One of the reasons the jury was out for 7 or 8 days is that some of the lawyers didn't agree with the recommendation made by a jury selection expert that I had brought in, Robert Hirschhorn. Robert Hirschhorn, I don't know if any of you have used Robert Hirschhorn, but he's very good at jury selection. And one of the reasons he's so good is that he can draw pictures of all the jurors so that you can no longer see them after they've been through. You can see the pictures and you can decide what to do. And there was a man who was a co-pilot, and there was a dispute as to whether he should stay on, and we lost that one. And the way the case ultimately came to an end, and there were hundreds of counts, or at least 100 counts, was that this man who was sitting on the jury after all these months of litigation, and he went into the clerk's office and said, I got to get off this jury. These people are crazy. These people all want to acquit, and they're wrong. Well, that's a bad thing to have happen after 5 or 6 days of trial, as you judges might know. 5 or 6 days of trial, and 5 or 6 days of deliberation. And so Judge Carr put it to us that we might waive or accept an 11-person verdict. And this man was removed from the jury, and an hour and a half later we had a verdict. Guilty on everything for all of the 7 defendants in the case. Trying cases with judges, and by the way, sometimes I think with judges being convicted where they really shouldn't be. I mean, we had a trial where an attorney was charged with making a claim for a bankruptcy fee in a case. I won't mention names, but you may remember the case. But and he had, I think it was $8,000 or something like that. And this was a case that was tried by, I can't remember which judge, but the bankruptcy judge, who was a very fine bankruptcy judge, was brought in to testify in the case that the lawyer had no legal right to make a claim for the bankruptcy, for the fee. And that was the basis for the conviction, for the prosecution and the conviction. And I had cross-examined the bankruptcy judge, who was a very nice man, but he was wrong. And he was convicted. In the Court of Appeals, what our argument was that the bankruptcy judge should not have been allowed to testify as a witness as to this question, and the government argued it was harmless error because I had demonstrated at cross-examination that it was not true. It was not accurate. I mean, that was really pushing the button. I had, but he got convicted anyhow because of the kind of situation that we had. Nikki and I have tried cases with lawyers. One case where we had Latino, black, and a Jew. We had 3 lawyers, and we had 3 lawyers on trial, 3 lawyers representing them, and they were acquitted. Most of the lawyers, really the most moving case in some ways was the Housel case. I had mixed feelings about the Housel case because Housel had been the prosecutor in another case that Gail and I were involved in, and that case was Cantrell case. Cantrell was charged and convicted of sodomizing, sexually abusing his own child between the ages of 4 and 8. It was a dreadful trial, and the man was essentially convicted to consecutive life terms, or whatever it was. And he was a 33-year-old man, college graduate, no record, working for a degree from the School of Applied Social Sciences or something else, something at reserve, and he was convicted and he was in prison. And we handled that case, and there were all kinds of errors in that case, and Judge McManaman wrote the opinion in that case. And one of the things that happened in that case that frankly I've never seen before, apart from the opinion itself, these sex cases are very hard to handle, but find it. Basically, there was a separate concurring opinion, and it was by Judge Corrigan, Judge Corrigan, and in that case, basically what he said is that the trial was such an abomination that he wished he could do something more than just this, as far as the prosecutors were concerned. And I suppose he could have, but I've never seen, we've had a lot of cases where that involved prosecutorial misconduct, and I've never seen a single case in which any disciplinary action was taken against any of the prosecutors who allegedly engaged in such conduct. You know, there is. I thought this was going to be a group of, I don't know how many people of you are public defenders. Any of you? Okay, some of you are public.
Plenty of us.
But I've known some great lawyers in my life. One of them was Gary Bello. Anyone know the name Gary Bello? Nobody. I would suggest, recommend to all of you that if you want to hear something about the epitome of lawyering, look up the name Gary Bello, B-E-L-L-O-W, and look up the 2000, memorial for him at Harvard in the year 2000, and just read some of the things that people have to say about Gary Bello. Gary Bello taught at Harvard Law School. He graduated from Yale Law School and Harvard undergraduate school, and got a master's degree at Northwestern in criminal law. And he and I were very close for a period of 3 years that I was in Washington. And he was an extraordinary man, an extraordinary lawyer, and he spent his life doing the things that lawyers can do and perhaps should do. And I have something here. He was being interviewed by another Harvard teacher, Gerald Messerman, who's a great teacher on law of evidence. But he's being asked by Nesson this question, basically: do you want to train great lawyers in your business? Is that what you try to do in both the clinical programs and otherwise? Is that what you want to do? Is trying to train great lawyers? And he says, in answer, he says, I don't want our students aspiring to be the other directed, recognition-oriented models of greatness that we put out. He said, one of the things Harvard Law School clearly teaches them is that good or bad, it's important to be important. That's not the message I want to communicate. I want them to be learners, thoughtful analyzers of the world, intelligent changers of their own behavior, respectful of the complexity of the world that they're going to live in. Fascinated with the life of learning and law will involve, that that a life in law will evolve over an entire life. I want them to be growing, changing, and value-oriented. Now, I think that's, one of the more profound things that I heard about, what we should try to accomplish in our profession. It's a very exciting profession. A lot of adventure in it, and, you can have, I think I added economic gain. It's quite possible to actually make a living doing this, even without being in a very large firm, and being in a very large firm. I think they're the ones who get the real big bucks, right? But it's so full of excitement and variety, and frankly, I've seen that we probably represented at least 20 lawyers in litigation, and most of them did pretty well. And most of them, when I said did pretty well, they did pretty well in the cases, and they also did pretty well as lawyers.